For those of you who don't know me, my name is Ann-Margaret Carrozza, and we're going to talk today about legal protections. I believe that legal protections are the next step in personal finance. You know, what does it matter if my portfolio rate of return is 3, 4, or 5%, if I have a 43% chance of being financially devastated in a divorce or other breakup, if I have a 60% chance of needing some type of expensive long-term care later in life, not to mention garden variety liabilities. You know, you can't turn on the TV during daytime hours without seeing ads from attorneys who want to represent you for all manner of perceived or actual offenses. So we need to be aware of how to protect our assets. You know, we know it's a very litigious society, and it's sort of ironic that this is what I do professionally, asset protection, because a few of you on the call, Mimi, and if Chris Hermanson is still there, you knew my grandmother, Lorraine, who was the slip and fall queen of Bensonhurst, Brooklyn. She fell, or she pretended to fall, and she sued more establishments than I can remember. Do any Queens folks remember a place called the Amber Lantern? We blame her for them going out of business because she had a pretty lucrative slip and fall there. We also blamed her for Beefsteak Charlie's going out. Do you remember the salad bar? She would bring a Ziploc bag and she had shrimp for the next month. So, but we want to, the linchpin of all legal protections and legal planning is staying out of court. And it comes as a surprise that we're more likely to be in court with a former loved one than with a stranger. And this comes about when relatives die, if there's any ambiguity, or if the documents are unclear, or if there are no documents. We want to erect guardrails so that there aren't explosions between loved ones and finances. So a typical example is a mother. If I give my daughter $100,000 toward a down payment on a house and I die, her brother may think that that $100,000 should come out of her share of the estate. You know, that's a reasonable thought. She may think it was a gift. Was it an advance against her interest in the estate, or was it a gift? You know, that is on the parent to try and anticipate what questions might come up later, and what can I do to add some clarity within the documents to keep our loved ones on good terms on the other end. So the number one document that we should all have to avoid being in a courtroom is what? A trust, because we should all have a nice will, but we want to avoid relying on the will because the will goes to probate. And it's definitely better to have a will than to have nothing. But the typical probate takes close to 1 year. And I think, Nancy, you've been in many situations where the family wants to sell a property and they can't because they have to wait for the court. So it comes as a surprise. I did a will. What do you mean I have to go to court? Well, it's very historically interesting from my perspective. It's a process that goes back to Henry VIII, but your last will and testament needs to be authenticated by the court. The surrogate in whatever county you lived in must physically examine the document, make sure that the staples weren't removed, and Everyone in the world will be given an opportunity to come down to that courthouse and challenge the will, give testimony that the person was not in their right mind, that she was subject to undue influence by my brother, and then the in-laws get involved. And it's not uncommon for a probate to take several years. So we want to avoid probate, and we can do that with nearly every asset class except real estate. So it's relatively new in New York State to be able to have beneficiaries on brokerage accounts. That only came into effect in the 1990s. But now we can have beneficiaries on everything except the deed to our real estate. So when we have real estate, or when we have a co-op apartment, we want to think about creating a trust. And you all know that there are different types of trust, and the trust that most people hear about out there is a living revocable trust. So a living revocable trust is very appealing psychologically because I can be my own trustee. I can put the assets in. I can take the assets back out. No one is the boss of me. No one is in charge of me. So that's great. I retain control. But what happens if I have liabilities? If, God forbid, I need nursing home care beyond the 100 days that Medicare and the supplement cover? Will that revocable trust protect my home and other real estate in the event that I need long-term care? And the answer is absolutely not. To the extent that I can get my hot little hands on the assets in a living revocable trust, so can my nursing home and other creditors. So the living revocable trust does one thing in this world: it avoids probate. And if that was our only goal, and we don't care about minimizing estate taxes, and we don't care about long-term care planning, then by all means, a revocable trust is the way to go. On the other side of the spectrum is a totally irrevocable trust, which is as rotten as it sounds. There is never a need to do a purely irrevocable trust. And by way of background, during my misspent youth in the New York State legislature for 14 years, I chaired the trust committee. So I don't know much about anything else in this world, but I know all about trusts. And I can tell you all conclusively that there is never a need to do a purely irrevocable trust. So we want to be somewhere in the middle, ideally. And the exact makeup of the ideal trust depends upon your personal situation. Are all of my kids equally situated financially? Do I have a son who is a neurosurgeon and he's doing very well financially, and I have another son and he's on my couch watching daytime TV all day, possibly through no fault of his own, I don't know, but will he be equally able to manage 1/3 of my estate later? Or do we need to customize how his 1/3 share goes to him? So that's what these discussions are all about. And maybe I want to give him 5% a year for 20 years to replicate a retirement account that I know he doesn't have. So every situation is different, but a typical structure of this mid-level trust, I call it a hybrid trust because it has elements of both revocable and irrevocable. I must appoint another person to be the trustee, but If the trust is properly drafted, I will retain the ability to remove and replace that trustee. Number one. Number two, I will want to draft the trust such that the trustee has no independent power to act without my written permission. That's incredibly important. So let's say I appoint Nancy as my trustee, and we get into an argument, not that I ever think that would happen, or she moves away, or she's not available on the day that I need her. And why would I need her? I would only need her for one purpose. If I want to sell the real estate or the co-op during my life, again, the trustee can't do it without me, but I do need that second signature. So think of the trustee as a convenient placeholder or a bouncer at the door. Requiring this second signature enables me to say to a nursing home one day, or to my soon-to-be ex-husband, that they have no interest in this asset because I, acting alone, can't get at it. Now, if I really wanted it, I would say, Nancy, please sign this paper to pull the real estate out of the trust. If she said no, I would say, thank you for your opinion. I'm going to pay the guy down the block $100 to be my trustee for 5 minutes and to get that second signature. So if the trust is properly drafted, I will not feel the difference at all with putting my primary residence. I can put a vacation property in there. If I have investment real estate and I did an LLC, I can put the membership units of the LLC into this family or hybrid trust. So I'm going to stop there to see if anyone has any questions on this trust.
I have a question. What's the difference between actually having a trust for real estate purposes versus having a deed that's in a life estate trust?
Okay, so life estate and trust are two different animals. And I used to do a lot of life estates in my practice until 2006. And the reason for that is the so-called look-back period that is currently federally 5 years. The look-back period for long-term care purposes is 5 years. That means that my real estate in this nifty trust needs to be in their baking for 5 years before it's legally invisible vis-a-vis nursing home care. Before 2006, the life estate, don't take notes on this because it's old law. The life estate used to have a 3-year look-back period. So all things being equal, we thought, you know what? Let's go with the quicker look-back period to protect the house. But the problems with a life estate are several. With a life estate, I transfer the property to Mary, Susie, and Johnny, subject to mom's retained right to live there for the rest of her life. Okay, that's great if we don't have a problem. If I need to go into a nursing home and that property is sold, we have a disaster because the Internal Revenue Code says that mom doesn't get her $250,000 capital gains exemption if she only owns a band of ownership represented by her life expectancy. So we get hit with capital gains taxes. And if I am in a nursing home, that piece that represents my life estate, let's say it's 23%, that would go to the nursing home. But the biggest problem with a life estate is that it can't hold other assets later. Later on, if I wanted to put a CD into the trust, I can, but we can't put a CD into the deed of a house, number one. Number two, if I name Mary, Susie, and Johnny as my beneficiaries on that life estate deed, and one of them dies, or one of them gets sued, or one of them is about to go through a divorce, I am powerless to do anything to protect their interest because it is vested. It is a completed gift. Whereas with a properly drafted trust, the parent or the grantor retains the ability to remove and replace the beneficiaries between and amongst, and you're going to fill out this formula based on your situation, but mine says between and amongst lineal descendants and trusts for their benefit. Because I hold these puppet strings during my life as to who gets what later on, it is not legally a completed gift. So we don't have to do a gift tax return. And if one of my three darlings has legal liabilities, because I am able to yank their interest away from them, their creditors can't go after my real estate. So I have literally not done a life estate since 2006. Occasionally folks come in with a life estate that's already done and they want to sell the property. And now if all of the parties are on board, they can take the life estate and put it all into a trust. And now we can magically get the parents $250,000 capital gains exclusion resurrected. Any other question on the trust?
Ann?
Judge?
So if you have this trust and part of what you're doing is to avoid your house being taken by, a nursing home or whatever, don't you have to also reduce your entire income to a certain amount, like 14,000 or something?
Yeah. We'll talk about income in a little bit. So let's think, we're talking assets right now. So that real estate, we want to have a trust. If we have a lot of real estate, I would not put 5 properties into one trust for general liability purposes. So we would think about doing LLCs or LLPs and putting some of the membership units of each of these entities into our master trust. Okay, so that's the real estate, definitely trust. Then we have retirement accounts. And if we have any teachers on the call, you have a big, beautiful TDA. The retirement accounts under current New York state law, the retirement accounts are invisible to long-term care issues. So now we have 2 categories of assets under our belts. We have the real estate in the trust. We have our retirement accounts. They're already invisible by virtue of New York state law. The only time I would want to make some changes is if my primary beneficiary, typically a spouse, if they die, it's not a problem. I mean, that sounds kind of silly, but if they die, the beneficiaries go to the contingent beneficiaries. But if instead of dying, my primary beneficiary has a long-term illness, let's say my husband, God forbid, has Parkinson's, he's in a nursing home, or he's at home with 24/7 care, do I want him to be the primary beneficiary on my TDA? Absolutely not. Because if I die unexpectedly first, then everything is going to go into his lap, which would put it in the hands of a nursing home. So just keep in mind that if someone gets sick, we want to change beneficiaries. Absent that, we're good to go on the retirement accounts, which leaves the everything else. Mutual funds, non-retirement brokerage accounts, money in the bank, whatever we have in this third category of assets, the planning is generally to delay putting those types of assets into the trust. And the reason for that is I told you that with the real estate in the trust, you're not going to feel the difference at all. However, if I put my last $5 in the trust, I don't care, what good terms I am on with my trustee. I don't want to have to go to them with a tin cup to get money to go get my hair done or go out to lunch. So it's important to have a balance. Yes, we want to protect all of the assets, but we want to enjoy our lives as well. So with a husband and wife or a married couple, I should say, we have power of attorney over each other. And with the power of attorney, we can very quickly transfer liquid assets between spouses without the 5-year look back period. So that's, one of our emergency cards. But what if both spouses have a problem? Or what if I'm a widow and I have $200,000 in the bank and the clock on my real estate has already been satisfied. So now the house is beautifully protected. The retirement accounts are beautifully protected. There's $200,000 in the bank and I need nursing home level care tomorrow. What can we do? Well, if we stand on our heads for a couple of months together, we can protect roughly half of that through rule of halves planning, the details of which would put us all to sleep. We can also take those monies. What we can't do with the money is gift it. And there's a big misconception out there that we can gift this money if we break it down into like Scooby snack size gifts. It is currently $16,000 per person per year that we can gift to third parties without incurring a gift tax. Medicaid doesn't care about that. They would simply add up all of those $16,000 gifts, and I would have a very big penalty, and we would utilize the money privately paying for me until Medicaid kicks in. So we have a special guest with us, and I've invited him to be with us today because one of the 11th hour planning strategies that I advise families is rather than lose this 100,000, 200,000, 300,000 that's in the bank and we can't make gifts with it, what the heck can we do with it? Well, it is not a gift if I use that money to improve my primary residence. So we can take that money and we can renovate the home. We can make capital improvements, ideally to ultimately inure to the benefit of my beneficiaries upon my death. So we want to take that 200, that 300 and invest it in the home in a smart fashion such that we are ideally getting as close to a dollar for dollar return when the property is ultimately sold. And the reason I've invited Jeff Brett, who is the principal of King Quality, you may have seen his commercials or ads. He is one of the top, he owns one of the top contracting corporations in the United States. And that's just not my subjective opinion. The #1 roofing company, GAF, in North America has designated 25 contractors in all of North America to have the highest possible rating. And King Quality is the only entity in the tri-state area that has that designation. Now, if I take the $100,000 and I, find a local contractor, maybe they're going to do a perfectly fine job. However, at resale, if I am able to say, I had this work done by King Quality, it's like, me selling a house and I have a Viking appliance in the kitchen. It's a name, it's a recognizable name, but more important than that is the work comes with a 50-year warranty, and the warranty can be transferred to the folks who buy my house. Is that not a more attractive way to go about doing a renovation? So with that, I'm going to turn it over to Jeff. And the question, I guess, that I am curious about, what is the type of renovation where you see the biggest chance for a dollar for dollar return? You're unmuted. Jeff, we want to unmute. Okay.
Thank you for having me. I
Yes,
appreciate it. And thank you for the introduction. And you're scaring me with all this talk. It's unbelievable. I think we have to start early. The number one thing really you can do to get dollar for dollar, it's actually going to get back 107%, 7% over what you spent, is a roof, because people that are buying a new home, they do not want to worry about the roof. So you get the roof done first. And like you said, it actually gives the next buyer peace of mind. And also it sets it up where the house sells faster. People that have sold their home recently said 33% of them, it was much easier to sell because they did a new roof. So the roof's number one. And then you really want to get curb appeal. And some of the curb appeal things are new siding, new windows, composite decking. In all of these things, siding's 83% return, which is still pretty close, but it's much better than paying to the nursing home. And windows are almost 100%. And a front door, believe it or not, is over 100%. And it's not an item that's that costly, along with a garage door, which is about 89% return. So these are things you can do fast and easy with $100,000 without losing it. And also will set the house up to sell for more and faster. And you have actually sent us some people that we've done this for. And just by the facelift and painting the inside of the house, kitchens and bathrooms, I know they seem like a great thing to do, but a lot of times a new buyer wants to put their own stamp on the house. So the kitchen, they might have an idea for the cabinets. So the best thing is the exterior and also basement space if you have money left over.
Thank you, Jeff. I want to come back to you in one moment, but the second part of having a relationship with a contractor, and so much of what I think today is about is just sharing information, and create a binder with all of this information. And maybe you say in 2 years, if I need to do some work, I'm going to get, I'll reach out to Jeff and his team for an estimate. But one of the things that we want to focus on, and especially the women that I work with, and I have an article on my website called Estate Planning and the Single Girl, because statistically speaking, ladies, we will be on our own one day. I have an 80% chance of being the surviving spouse. So we want to take steps ahead of time to make sure that our later years, and that's the good news, we're living longer. We want to make sure our later years are lived out in comfort and on our own terms. On my website, I have my own living will. A living will is not something you need an attorney for. A healthcare proxy is not something you need an attorney for. I think attorneys who charge for these things should be ashamed of themselves. the healthcare proxy law, which I was a co-sponsor of in the mid-90s in the legislature. That's designed to be user-friendly. You don't need a lawyer, you don't need a notary, you need 2 witnesses, end of story. If you do nothing else today, download that silly healthcare proxy, fill the healthcare proxy out. You're going to feel a little bit more empowered over this whole process. But the living will, where we kind of list what we want and what we don't want in terms of long-term care, I put a statement in my living will that says, in the event that I need long-term care, it's my wish to have the care provided in my own home, unless it's not medically possible. So, imagine if, God forbid, one day we have, a dementia-related illness. Am I going to be happier and more comfortable in my own familiar surroundings? Absolutely, 100%. So we want to think in terms of looking around our house and imagining whether it will lend itself to aging in place. And that's another, pivot point where I do refer families back to King Quality, because Jeff has a team that can come out to your home, can come to your parents' home, and just check it out and give you some ideas going forward. Do you have anything to add to that, Jeff?
And that's a great point. And it's something, even the tub, to have a walk-in tub or a walk-in shower. The older homes are always built with a regular tub that you have to step over. And it's one of the #1 places somebody aging is going to slip and fall. So just to have a walk-in tub or a shower, it's been a really big thing the last 10 years because Long Islanders are aging in place. And it's something you do have to think about.
Can I ask you about the walk-in tub? A question I always have about it is, do I have to stand there and wait for the water to drain out before I'm able to open that door and exit?
That is one of the issues, and it does get a little colder, but it has a little bit of a lip, so it's not all the way. And the drains are actually a little bigger, than a regular drain. So it does empty out. And that was a great question because it does get a little chilly.
Yeah, so this is definitely when it comes to investing in, for most people, our single biggest asset, our home. We don't want to be a penny wise and a pound foolish. And,
No.
when I was a legislator, I had many homeowners come to me because they wanted to go after their contractor. The person took a deposit to supposedly, go buy materials, and they never heard from the person again. And, good luck trying to find them. And the one that, will be burned in my brain for the rest of my life, and I tell the story in my book, is a widower living alone in Whitestone. A contractor, a father and a son with it looked like a legitimate truck with some equipment. And they came to the door and they offered the homeowner, because they were doing work in the neighborhood, so they could make him a super deal, for $50, they would spread this acrylic polymer coat on the roof to extend the life of the roof. So I know next to nothing about any of this. And I imagined if I answered the door, I'm thinking in terms of, clear nail polish, right? It sounds kind of reasonable to me. And the homeowner thought, what do I have to lose? If it works, great. It's extended the life of my roof for a couple of years. If it doesn't work, I'm only out $50. So the father and son team go up on the roof. They did whatever they did. They came back down and they said, oh, brother, do you have problems up there?
Oh my God.
Yeah. And the homeowner said, well, I've never had a problem. And they said, okay, well, here's our card. And what do you think happened the next time it rained? He had flooding. So these despicable people Unfortunately, the homeowner was able to find this creep's card and called them, and they gave him a very big estimate for the repairs. And he explained that he only lived on his Social Security check. He didn't have that kind of money. So they arranged for financing for him. Long story short, what he really did was sign over his house to these people because he couldn't keep up with the enormous payments. So that was, really a horrible story. And he realized what happened, but he was too ashamed to tell anyone about it. He was afraid that he would be determined to be incapacitated or something. But there was a happy ending here. Our district attorney at the time, Richard Brown, did find these folks and prosecute these folks, and the guy has his house back. But there are
That's
a
awesome.
lot of slick and shady operators out there, and you don't want to be in this game of Russian roulette. So, with that, Jeff, if you have any final thoughts on what to look out for.
And it's sad to say that's a common story, and it's horrible, and it is very scary. One of the biggest things to watch out for is just door-to-door people knocking on your door. If your friend doesn't recommend them, or you can't look them up on the internet and check out their Google reviews to make sure, today everything's at our fingertips. You can make sure they're licensed, you can make they're insured, make sure they have a place of business. It's just a simpler thing to go with a name that you know. If you haven't heard of them and you can't check them out anywhere and they just knocked on your door, it's a good idea to close the door, because that story, it's horrible, but I'm sad to say it happens a lot. And it's definitely something that is avoidable if you just don't go for the door-to-door salesman.
Yeah. And Jeff, where can folks check out pictures of your work?
That's a great question. For us, you can go right online, just Google King Quality, and you'll see us online. And one of the things to look for in a customer is Google reviews are something that can't be manipulated, and they're actually very hard to get. And we have 1,500 Google reviews. We have a 4.9 rating, and it's something that I'm proud of. And most companies, if you go online and you Google and look at them, and they don't have reviews, and they have all bad reviews, it's safe to say something's wrong. So on our website, you can see pictures of our work, you can see our reviews and stories of customers and testimonials.
Thanks so much. Thanks.
Thank you.
Do we have any questions on trusts before we move on to another topic? Anything in the chat, Andriana?
We have one question that you sort of answered prior. It was a husband and wife Medicaid trust. They both funded it for benefit of their only daughter, who's a minor. Husband dies. Why does wife have a spousal right of election? Seems like the trust wasn't worth it.
Okay. So first of all, if we have a minor child, we never want to name a minor child in their own name as a beneficiary within our wills, within a trust, or on an account. And, it sounds counterintuitive, because as a parent, we want our little ones' names to be on these assets. But going back to the Little Rascals, and I don't think any of us remember the Little Rascals, but we know what it was. Jackie Coogan played Spanky, and he was at one point in time the most famous person in the United States. And he was a child, of course, and didn't get his assets until he reached adulthood. But lo and behold, when he turned 18 and was expecting his millions of dollars, there were no dollars because the parents spent it all. So it was really a tragic story. He was destitute after all of those many years entertaining everyone in the world. So every state in the United States enacted so-called Jackie Coogan laws. And the law says that a child cannot own something in their own name. It has to be under the supervision of someone appointed by the court. So the law no longer assumes that the child's parents are going to do the right thing. So if I name a 7-year-old as the backup beneficiary on a life insurance policy, that thing is going to court, and the judge is going to appoint, and I'm not asking, you can keep a poker face, Judge Heyman. The judge is going to appoint a friend to oversee the 7-year-old's money. And this is called guardian ad litem. And if you say those 3 words to any of your attorney friends, their eyes are going to get bigger. It's like a Scooby snack. It's like finding $100 on the sidewalk. Guardian ad litem means that for overseeing this child's money, you're going to get a big piece of that child's money. And that's, not what any of us want. So for all of us who have youngsters in our lives, it's as simple as creating little trusts for each of them, funding it with a ceremonial $10, but that trust is structured to say that the assets are paid out to the young person. My kids' trusts say 1/3 at 25, half of what's left at 30, and the full distribution at 35. When I name this little trust as the beneficiary, now we've bypassed the court. So in your example, where the surviving spouse was the beneficiary of the trust and a minor child was the backup beneficiary, we want to have the trust for the minor child as the backup beneficiary. Right of election refers to what a surviving spouse is entitled to if the decedent tried to cut them out of everything. So we are free to distribute our assets at death to anyone in the world, but we can't totally cut out a spouse. We may want to cut out a spouse if the relationship is in threads and for whatever reason we haven't gotten divorced. And we may also want to cut out the spouse if they're in a nursing home. So if I do a trust and my spouse is in the nursing home and I die, and my trust says it all goes to Mary, Susie, and Johnny, even though my spouse in the nursing home is not necessarily bringing a suit against my estate, the Medicaid program can do it on their behalf. So the question is, why did I even bother to do a trust? Well, if you didn't do the trust, they'd be entitled to 1/3 anyway. And because you did the trust, they're entitled to 1/3, but we would settle with them. We would say, yes, you're entitled to 1/3, and it's going to take you 2 years of chasing us around court to get it, or we'll give you 1/6 right now. So it's like a negotiating opportunity. But it really begs the question, why didn't that couple have a prenup? And 95% of folks don't have a prenup because it's awkward. They think it's unromantic. They don't want to, go into the marriage thinking about a divorce. Well, the rules for a divorce are already in place. The only problem is they were written by someone else. They were written by legislators in Albany. If you want to customize anything, you want to do a prenuptial agreement. Now, for parents of adult children on the call, there's a very real concern, right, about leaving assets to children when there is a 43% divorce rate. So for some of my clients within this trust, we say that upon my death, everything goes to Mary, Susie, and Johnny. We can also add on the condition that they take legal steps to keep assets inherited by us within our lineal descendant line. So that will require them to create a prenup, a post-nup, or a cohabitation agreement, as the case may be, at least to the limited extent any assets inherited or gifted from my mother or from my parents will be off limits in the event of a breakup. But if within that prenup or post-nup, we have the spouses waive their right of election in each other's estates, that's going to protect it from a nursing home, because then the Medicaid program can't assert that right of election anyway. And I tell people that I think even happily married couples need to do a post-nuptial agreement. Why is that? Well, in my own life, that I am, relatively happily married. And if I die, the assets go to my husband. No, I'm very happily married, in case anyone is friends with Bill. But I believe he would be remarried in like 3 months. There's just no question about it. He doesn't know where anything is in the house, and I question his ability to get by on a daily basis. So he would be remarried. And, given my peculiar line of work and seeing the very best and the very worst in human motivation, I believe that that new wife will be trying to get his assets, from day one. So in order to protect my children from, this go-go dancer that Bill may take up with later, we have a post-nuptial agreement. And it says that the survivor of us promises legally to enter into a prenuptial agreement with any new future relationship for the purpose of keeping jointly accumulated assets separate for the benefit of our lineal descendants. Now, you can customize that, but it's an example of trying to think a few steps ahead and what can we do to prevent a horror story with the assets. Any questions, issues on that piece of it?
It seems a popular topic is in regards to real estate. So can you sell your house and use the trust money to buy another one? Is the new home protected by the original trust, or is there another 5-year look back?
Okay, that's a great question. And it's like a game of dominoes. We want the ends to line up correctly. So when someone is selling real estate from within the trust is structured under the Internal Revenue Code to be what's called a grantor trust, meaning it's disregarded for income tax purposes. So if I sell the property from within the trust, we continue to benefit from the 250 and 250 capital gains exclusions. The only, tiny speed bump is we need my signature and we need my trustee's signature. Okay, we get the 2 signatures. The new people make the check payable to the Ann-Margaret Carrozza Asset Protection Trust. If I hadn't done so up until that point, I'm going to open a bank account in the name of the trust, negotiate the check, and from that account in the trust, we're going to buy our replacement residence. So as long as everything occurred within my little turtle shell, we didn't break the spell of this 5-year clock, the 5-year look back period. So it was a good question.
All right, an additional question is, my parents have a personal residence as well as a rental property. They're thinking of putting it all in a trust. What specific trust should they put real estate in? Can they continue to use the rental income to live on and continue to be in charge of these properties?
Okay, so that's a great segue to what's going to be the next topic, which is taxes. Yeah, it depends, you know, provided that you have a good umbrella policy, provided that someone has vetted these tenants, has checked their credit scores. If you have decent tenants and you have a rental property that you keep in good shape, your liability risks are lower than if I have some, you know, rotten property with low life tenants. They're probably going to be suing me at every opportunity. Yeah, you can put a rental property and your primary residence into this same trust, and the terms of the trust say that the grantor retains all rights to the income generated from the properties. The only time I'm going to go into the back of that trust and turn off the income faucet is in the event that we need long-term care. So the week before applying for a long-term care program, we're going to have the parent disclaim their future rights to the income. And that's going to protect the income. But in the here and now, yes, they're entitled to retain full control and all of the income. Now, when we start to have so many properties that we have an estate tax situation, then we need to move to a second trust. So the trust that we talked about so far can comfortably hold up to $6.1 million worth of property, because that is the current New York State estate tax threshold. I can bequeath up to that amount free of estate taxes. And I also want to point out, with this first trust, with the hybrid asset protection trust, when the property goes automatically to the named beneficiaries, they get a full step up in basis. So it's going to protect them from a capital gains hit, unlike a very primitive transfer to them. You know, a lot of people say, I want to keep it simple. Hearing about trusts gives me a headache. I don't like it. I'm just going to turn the house over to the kids. Well, this is really penny wise and pound foolish, because now my original purchase price of $50,000 from 1978 becomes the kids' cost basis. And even if they are nice and they let me live out my days there, when they go to sell it later, they're going to be taxed on every dollar over the original purchase price. So never just do a simple transfer to the kids. Okay, so if I'm a single person with $7.1 million, I need to take that last 1 million and I need to put it into a second type of trust. This trust is an estate tax trust. The current federal estate tax exclusion is $12 million. That is scheduled to come crashing back down to 6 million in January of 2026. So we have a little window where Treasury has indicated we can use some or all of that temporary $12 million transfer tax credit to paper over what would otherwise be a taxable gift now. So to put it into English, if I have 7.1 million and I have 6.1 in my hybrid asset protection trust, I'm going to take the last million and put it into an estate tax trust. I will have to do a gift tax return for that gift into the estate tax trust by April 15th of 2023. And I'm going to use $1 million worth of my temporary $12 million transfer tax credit. And at the end of that gift tax return is going to be a big zero. But by doing this, I have grandfathered for myself the benefit of this temporary, really high federal estate tax exclusion. And if you're saying, you're rolling your eyes that your current assets are nowhere near these numbers, I want to point out that what goes up can certainly come back down. And when the sugar high of all of this federal stimulus money to the states wears off in the next couple of years, I fully expect my former colleagues in Albany to bring the 6.1 million back down. When I first started practicing in the 90s, the estate tax for New York was $108,000. Everyone with a house paid New York State estate taxes. We're a little bit spoiled now, but we can't let it leave our brain entirely because it very well could come back down in the future. Any questions on the estate tax? Well, one more point I want to make about the estate tax is your life insurance is includable within the estate tax base. So anything passing at my death gets tallied up when they're determining whether to assess estate taxes. Life insurance, they say, is tax-free. It's income tax-free. It's not estate tax-free unless this life insurance is owned by a special life insurance trust, also known as an estate tax trust. And now we're going to keep that death benefit out of the gross taxable estate. So it's important to be conversant with that. Are there any questions on the estate tax, Andriana?
In regards to estate tax, no, but there are questions following up in regards to two questions that actually relate to each other. Whether an investment portfolio can be housed and managed from within a trust. And another question in regards to a participant who says that one of her children, she's a widow with two sons, one of her children are married, and should she create a trust for two grandchildren minors so that if the son dies, money from the brokerage accounts and retirement accounts go directly to them, and should their mother, her daughter-in-law, be a custodian?
Okay. So yes, the trust, the hybrid asset protection trust, can own a brokerage account, an investment portfolio. And as long as you have a good relationship with your trustee, you're going to whisper in their ear, what transactions you want them to execute with the broker on behalf of this portfolio. And you can get the investment income from it, but you shouldn't be taking principal from it because that's going to degrade the integrity of this trust instrument. If it looks like I can, make withdrawals to myself, even with the permission of the trustee, then a nursing home would be well within its rights later on to say, hey, you were able to put your hand in there for X, Y, and Z, so why don't you go pay for your own nursing home care? So what we put in the trust can be managed and can grow, but we really want to put things in there that we don't think we're going to need on a daily basis. So if I'm 86 and I still want, my money in my name, and I have 1 million in cash, I might recommend that the 86-year-old keep in her own name whatever amount makes her feel independent and good. Maybe that's 100,000, maybe it's 200,000. And let's put the rest into that asset protection trust to get that clock running. So the clock is 5 years federal level for nursing home Medicaid. For community Medicaid, the clock is much shorter. We have 6 more weeks. For any of you that have family, friends, neighbors who could use some help, they'd be well advised to consider community Medicaid, because there is currently, for 6 more weeks, no look back period. So if I have 200,000 in the bank and my daughter with the power of attorney puts the 200,000 into the asset protection trust, we can apply for community Medicaid before April 1st of this year, and they will not look back. As of April 1st, they're going to gradually implement what will ultimately be a 30-month look back period. Okay, so back to the other part of that question. I would create trusts for the benefit of the grandchildren. I would put $10 in each one. They would get their own tax ID numbers so that they're like pulsating active entities right now. And they would be the beneficiaries of the asset upon the death of your child. Can the daughter-in-law be the trustee of this? Well, for you to even ask that question means you like and trust your daughter-in-law. So in that case, by all means, yes. For the overwhelming majority of folks I know, however, that's not their preferred course of action, in which case I would make another child of mine, so the little one's uncle or aunt, I could make them the trustee as well. But again, super important to have little trusts for the benefit of all of the little ones in our lives.
There's one question in regards to tax valuation. If a brokerage account is marked TOD, is that brokerage account included in estate tax valuation?
Yeah, and I'm glad you brought that up, because there's a big misconception out there that if the asset avoids probate because it has a beneficiary, or if it has a surviving joint owner, that it will somehow avoid taxes. If it were that easy to avoid estate taxes, the government would not collect any estate taxes. So anything passing at my death gets added up, and the sum total of that, whether it went to a beneficiary, or I had a transfer on death account, or we had a joint bank account and there was a surviving joint tenant, what percentage of that joint account do you think is includable in my gross taxable estate? The answer is 100%, unless the surviving joint owner can prove that they contributed any of the consideration toward that account.
Oh.
Yeah, so I think we've covered quite a bit of ground, and I think this would be a good place to leave today's discussion. For those of you with us today who are existing clients, and you did this trust with me, 5, 10, 15, 20 years ago, there's no reason to redo the trust in a vacuum unless something changes in your life. So again, as the assets creep above what is the current state estate tax threshold, we would think in terms of implementing a secondary structure to catch the fall off, which would otherwise be subject to estate taxes. Do we have any last question, Andriana?
Yes, we do. We have, if you don't mind, to answer
Yeah.
2 questions. One's short and one's a more expanded
Okay.
question. So I'll start with the short one. If your trustee passes away, how do you appoint another?
Oh, okay. So remember when I said that if Nancy is my trustee and she moves away, I can make a change. So it's very important within the document To name a trustee, I can name 2 trustees if I have 2 kids for public relations purposes. I will also want to name a backup trustee, but I'm also going to say that the settlor reserves the right to remove and replace a trustee for any reason at any time. So that's a very important power to have to deal with curveballs. What's the other question?
All right. Parents' properties, including both residential rental properties, are put in a trust. When parents pass, their 3 children inherit and decide to sell. What is cost basis? Is it the date of death?
Date of death. If it comes out of, I keep coming back to this mantra, a properly drafted trust. You can have a trust that's a piece of garbage. And in the book, I tell the story of an attorney colleague who's a personal injury attorney, and he was doing a trust for a client. I don't know why, but he asked me if I would look at it, and I looked at it all right, and it was a piece of garbage. It was a total disaster. I called him and asked for more information about the client. Should he have given me information about the client? No, but he did. He faxed my office everything, all of their account statements and social security numbers. Long story short, I drafted a decent trust for him, and he then put out a shingle saying he does elder law, with that one trust that I don't even use that type of trust anymore. So it's like a broken clock. Maybe it's right, maybe it's wrong. You need to really be a partner in the planning process. And the language can be dry, but you want to sit and go over it. It's like modeling clay. And the process really should end up resulting in a great structure to protect me during my life and my kids after my life.
Okay, I don't know if you have any more time, but we have 2 last questions. One is, what about irrevocable trust with a reverse mortgage? And the other is, can you make your own power of attorney? And so what would make it stand up in court?
Okay, so power of attorney is not a document I would do on my own. The banks love to give you a very big hassle with a power of attorney. I told you you can and should do a healthcare proxy and a living will on your own. Power of attorney, I think that should be done by an attorney. What was the, reverse mortgage. So you would do the reverse mortgage before putting the house into the trust. And then the house would go into the trust subject to either the reverse mortgage or a conventional mortgage. And there's federal legislation from the 80s saying that a bank cannot enforce a mortgage acceleration clause if the transfer of encumbered property is into a trust with certain provisions that we don't have to get into. So you don't have to ask for permission from the bank, but I would get that financing in place before transferring the deed into the trust. Okay, so if anyone has any follow-up questions, please reach out to me via email through the website. And the website is myelderlawadottorney.com. Instagram is @mylawyerAnn. And I wish you all a very happy Valentine's Day. And I can't help but give some advice to the gentlemen who were on with us. Really avoid the supermarket flowers. I don't know, they're spray painted, all different colors, and just super quickly. I had occasion to get supermarket flowers for Valentine's Day 2 years ago. So I went into the kitchen and they were still in that tacky plastic on the counter. And I said to myself, is this what we've come to, oh, the supermarket flowers. And then I thought, you know what, and be nice, be gracious, open it up and cut them down and put them in a lovely vase, which I did. And as Bill came through the room, I thanked him graciously, and he said, "You're welcome." And then I hear my 18-year-old, "Did anyone see flowers?" So he bought them for some person at school, and he was planning to bring them into school that day. I assumed they were for me, and Bill did take the credit of getting those flowers. Yeah, so that was a tough chapter. So I hope all of you avoid a similar fate. And I said to him, just get me a card. That would have been so much better.
Excellent.
Anyway, please feel free to keep in touch. I love talking about these issues. For those of you who've already done your planning, keep the conversation going. And I hope that I've given you a few little nuggets with which to embark upon future planning. And to the Legaz team, my partners out there in the community working together to help folks, thank you for setting this up. Bye, everyone.
Thank you.
Goodbye.
Thank you.
Thank you
Thanks,
so
Ann.
much. This is very
Thank you.
helpful.
Thank you.
Thank you so much,
Thank-
Ann-Margaret. Thank you.
Bye.